Because the High Court in Makhanda has set aside a decision by the Energy Minister Gwede Mantashe to grant oil giant Shell a permit to conduct seismic surveys on the Eastern Cape Wild Coast. The Legal Resource Centre has confirmed this to Newzroom Afrika. The judgment is in relation to Part B of the case, in which the applicants argue that Shell does not have the necessary authorisation to undertake seismic testing. They further argued that the company failed to properly consult the affected communities and that the testing would violate their constitutional rights. Judgment was handed down this morning following a two-day hearing at the High Court in Gqeberha. LRC lawyer Wilmien Wiccomb says that this is a huge victory for the Wild Coast community, and I believe is now able to speak to us. Wilmien, a very good afternoon to you. If you can hear me, thank you so much for your time. You must be well pleased with this outcome today.
Yes, we certainly are well pleased, and so are our clients.
And let's go back a bit and talk about why it is that you ultimately had to go to court, because this is in fact an issue that's been in and out of the courts in the Eastern Cape.
That's right. So the permit was initially granted to Shell in 2013 already, but no one was aware of it. I think everyone publicly and certainly our clients became aware of it at the end of last year, when it became clear that Shell was finally going to start exercising this permit and start a seismic survey off the Wild Coast. So our community clients are the people living off the Wild Coast, the most directly impacted. They live not only off the ocean to feed themselves, but, you know, the ocean is central to their spiritual and cultural lives. And so they had no idea. They were not even notified that this was in the pipeline. So they approached the court at that time on an urgent basis, asking for an interdict to stop Shell from commencing with the survey, pending a ruling by a high court as to whether these permits were actually granted lawfully. So the interdict was granted in December, and what was now found by the High Court of Makhanda is that indeed both the 2013 permit and the later renewals were unlawfully granted to Shell, and so at this moment Shell has no permit to explore the Wild Coast.
But it can still reapply, am I right?
So they can certainly now apply for leave to appeal, which we assume they will do.
And I know I said we're speaking about the genesis of this case. Let's stay just a while longer. You mentioned that the communities, weren't consulted. That's been a major issue in the legal battle. But it would also have, you say, the seismic survey, if it were to proceed, very real-life implications outside of their earning.
That's right. And so those were two key considerations for the court. So I think on the first point about consultation with the communities, the judgment makes a very important statement. So Shell argued that they did consult these communities because they had consulted with 3 monarchs in the former Transkei. And so they said that is the same as consulting with all the communities on the Wild Coast. So, I mean, that is the kind of approach from the state and companies that rural communities have been complaining about for years, saying, you know, why are we not seen as individuals who must be consulted as individuals? Why are we seen as, you know, invisible members of a community and that the traditional leader can speak on our behalf? So the court here said that there's no law that entitles a traditional leader to speak on behalf of his or her community. And so, you know, Shell was wrong in assuming that that counted as consultation. That, I think, is really important. Then the court indeed also said, at a very minimum, the minister should have considered the impact of the survey on these communities. That means the impact on their livelihoods, also the impact on their spiritual and cultural practices, which is key to them. The court didn't make a decision as to what the minister should have decided. The court said simply, for the decision to be lawful, you must take these things into account, and the minister simply didn't.
And in previous comments, I just want to read for you and our viewers, the minister had said this. I'm looking at an article from IOL, in fact, quoting the minister last year sometime, where he said, South Africa deserves the opportunity to capitalize on its natural resources, including oil and gas, and these resources have been proven to be game changers. Elsewhere, he then said, we consider the objections to these developments as apartheid and colonialism of a special type, masqueraded as a great interest for environmental protection. Those comments were made, as I was saying, sometime last year.
Yes, and they became very pertinent to the case because Shell argued that our clients were not entitled to approach the court, that they first had to do an internal appeal to the minister. And our client said, well, this is what the minister says publicly. We cannot be expected to approach that minister for an appeal and assume that he will be objective. And the court agreed. The court said there's clear bias here. And secondly, the court also mentioned that, Shell and others told the court that this was going to bring enormous economic well-being to a very poor province. And yet they could not provide any evidence that that was actually going to happen. These just continue to be vague statements. And the court noted that and said, it's not enough to make promises. You have to show that this is actually the case.
So what does fair consultation now look like, or what should it look like, given that the minister's level of fairness has already come into question, the legitimacy of a process where only the say-so of traditional leaders was prioritized has proven problematic? What shape should it now take if indeed Shell wants to proceed with this?
So Shell and any company that now wishes to apply for any sort of right, they must identify the people who will be directly affected at a minimum. And they must ensure that those people know not only about the application, but what the impacts may be. And they must consult with those people, the court says, in a way that is designed to reach some sort of consensus. So it's not a tick-the-box exercise at all. And yes, that's going to be a lot more trouble for companies. It's much more difficult than what they've been doing up to now. But that is what the law requires, and that is how we are going to protect our most vulnerable communities in South Africa, who always bear the brunt of these mining projects.
Am I right to say they've also been ordered to cover your legal costs? And if so, how much would they have to pay?
Yes, they have been ordered to cover the costs of all the applicants. And so there were 3 legal firms involved. And, of course, quite a number of counsel. It was a very, very complex case. I think there were more than 30 lawyers in the courtroom. I can't tell you exactly what the cost order will come to, but yeah,
but it's a
I'm
huge
sure
tab, nonetheless. Wilmien Wiccomb, good to speak to you. She's a lawyer with the Legal Resources Centre.